Well, good afternoon, everybody. Welcome. My name is Christina Fox, and I am the CEO here at TechAlliance, and we have a deep sense of gratitude and respect for this land, waters, and resources that are protected by Indigenous peoples for centuries. And I want to acknowledge that this is the traditional territory of the Anishinaabe, the Haudenosaunee, the Lenape, and the Anawandron. Honoring all the original peoples of Turtle Island, TechAlliance does remain committed to working alongside allies and Indigenous-led businesses to advance prosperity for the region's First Nations, Métis, and Inuit. It's hopping here today at TechAlliance headquarters this morning. We actually hosted an in-person invite-only experience with Frere Wealth Advisory, where they were talking with founders and running through different strategies and scenarios to extend runway, to look at if you're raising or you're a recipient of non-dilutive funding, how to extend your cash flow and different sort of scenario environments. The folks that were here today had an incredible time, and I encourage you, if this is something that you're interested in for the next time, to get on the list. Go ahead and send a note to our host, and Sarah will be sure to pass your name along to Andrew and the team. And if you have a curiosity with the enthusiasm I just shared about the experience and you want to connect in with our friend John directly, Sarah's going to drop his email in the chat. And if you have any questions about that, feel free to reach out to any one of the humans on our team. We're happy to talk with you about the advantages and value of some of the different partners that we work with. So as many of you might already know, that TechAlliance does empower world-class ventures and fuels growth in Canada's innovation economy. And we're a unique organization with opportunity, providing entrepreneurs and ventures at all stages with professional development, story amplification, mentorship, coaching, connections, access to capital, customers, and talent to ensure innovative economic growth across Southwestern Ontario, calling attention to the incredible world-class companies that are operating in this region and that have joined us today. So what this means is we have a team of venture growth advisors that have had a founder's experience that can support you as you face opportunities and challenges within your own growth. And there's so many other reasons to become an Alliance member, like amplifying your storytelling by sending us your press releases so that we can push it out to local and national media contacts. On social media, if you've got a really cool update that's happening in your company, feel free to DM our accounts. We'll share, like, repost, and amplify, because that's part of what we want to do. Again, to call attention to the founders, early stage founders right through to unicorns in the making who have recurring revenue in the scale of what many of our entrepreneurs dream of. And so if that is of interest to you, it's a really easy thing to just shift and make a DM and push that over to our team. If you're curious about the way that we do press releases and gather media, again, feel free to reach out to anyone that you know on our team. And if we're not the right person, we'll put you in touch with the right person. You know, in these uncertain times with the tariffs, our advocacy efforts continue to drive value in supporting entrepreneurs and scaling technology companies with all three levels of government, sharing the stories of the impact that you're facing, whether it's the value of the Canadian dollar, whether it's upstream or downstream supply chain, whether or not, if you're a software company, you know, the recurring licensing, if you're a med tech company, some of the regulation obstacles. If you're a large scale company, sometimes it's related to talent and newcomer talent. There's so many different things that we're advocating for. So if you've got a first person story, even if you want the company to be anonymous, don't hesitate to pop me a note so that I can include your story in the next conversation I have with a public servant or an elected official. So on that end, if you're not a TechAlliance member, it's really easy to get going. You can get a conversation started with our team, learn about some of the things that we do, join our upcoming experiences, participate in tech meetups, and exchange some of your ideas. So I invite you to subscribe to our newsletter. That's where you'll find out about more things that you can get involved in. And I know that our team is going to drop our links to our socials and our newsletter, and it's a quick and easy way for you to engage. The nice thing about a virtual masterclass is that it's pretty easy on your end. The bit of housekeeping is that this will be available for replay. So if there's a person within your team that you want to share it with, feel free. You'll receive that after we conclude. And if you have any questions, if you can drop them in the Q&A feature, that's where I'll look for your questions. If you drop them in the chat, sometimes I'm not good to go between the two. So feel free to drop questions in the Q&A. And after Genevieve completes her presentation, we'll take on some of those questions, and we've got a few prepared just in case. So let's get to it. For any tech and innovative business, no matter where you're at, the landscape changes so frequently. And we know that employees are the most valuable assets. So Innovation, trade secrets, and sensitive company information also calls for strong command on the employment laws for your company. So leading the masterclass today is Genevieve Cantin, who's an associate at Miller Thomson, practicing in the firm's labor and employment group. She's known to offer practical advice and forward-thinking advice for representation to employers in a wide range of industries. And I think she's particularly excited to be joining us with an audience of folks who are part of the tech sector. So with broad knowledge and experience in advising clients on discipline, discharge, employment standards, occupational health and safety, human rights, wrongful dismissal matters, enforcement of restrictive covenants, and issues arising from both corporate reorganizations, mergers and acquisitions, often common in our sector, Genevieve's approach ensures that clients' rights and interests are well protected. So in today's 1-hour session, she's going to speak about the complexities of employment law. And at the end of it, we do hope that you leave with valuable tips on different legal obligations, protecting the workforce, and crafting employment contracts that safeguard your business, and much more. Some of you may be deep practitioners in an HR space that may learn something that is a helpful tip on the way that you already have processes in place. And if you have questions for Genevieve, she's going to share her contact information. She's happy to take questions outside of this conversation that are more specific to what you're facing. So before I pass you over to Genevieve, I feel like I'm doing a real long commercial, but it's really because I'm excited about TechAlliance and even excited about one of our longtime supporters, our Masterclass series sponsors, Robertson Hall Insurance. We want to always thank them for their continued support to the growing tech and innovation sector in London and region. TechAlliance members, which most of you are on this call, can take advantage of exclusive discounts by Robertson Hall Insurance. And for more information, visit the link that Sarah's going to drop in the chat. And I guarantee you're going to be well taken care of by Erica at Robertson Hall. So with that, Genevieve, I think you're going to come on camera now, and I'm going off camera, and it's over to you.
Thank you very much, Christina. I believe I'm already on camera. If I'm not, please someone let me know. So good afternoon. As Christina said, my name is Genevieve Cantin. I'm an associate with Miller Thomson in our London office. My practice is in the labor and employment group at the firm. I want to thank each of you for attending and spending your lunch hour with me. I know you have to eat, so that's obviously more important. And thank you to TechAlliance for hosting this presentation and having me today. So before I get started with today's presentation, I want to give you an overview of Miller Thomson and some of the work that we do. Bear with me for a moment here. Okay. So Miller Thomson is a national law firm with more than 500 lawyers across 5 provinces in Canada. We offer a full range of legal services in litigation and business law, expertise in technology, intellectual property, privacy law, mergers and acquisitions, corporate finance, securities, financial services, tax, restructuring, insolvency, and obviously my favorite topic, labor and employment, as well as a host of other specialty areas. You name it, we probably do it. So keep that in mind. We understand that running a business is hard work and that business owners wear so many hats, it's hard to keep track of. Whether your emerging business is in its early stage, is looking to further expand, or needs guidance on the day-to-day operations and direction, we have the knowledge and the resources to help you power your business forward. To give you a bit of information about our labor and employment practice, we have more than 40 labor and employment lawyers across Canada. We are in all the provinces in which we have offices, and we do have some professionals who are qualified in practice to practice in other provinces in which we do not have offices, which is obviously an added benefit for us. We also have strong relationships in provinces and territories in which we do not have offices. We support all business sizes, from very small startups to large international corporations operating in Canada, both union and non-union work environments. And we do everything from drafting employment contracts to negotiating collective agreements to defending wrongful dismissal actions, unfair labor practice complaints. Now, I won't list for you the full range of our services. If you're interested in learning more about our services, I've inserted 2 slides at the end of my presentation today that just gives an overview of some of our practice areas in labor and employment, and some things that my team or our team here at Miller Thomson will deal with on a day-to-day basis. If you have questions, I will insert my email and my telephone number in the chat, but they're also listed on, I believe, the first 2 slides of my presentation. So be sure to check that out if you do have questions. So turning to the presentation today, the masterclass is not intended to be an employment law 101 course. So if you already don't want to participate, I get it. Feel free to go have your lunch, and but certainly I hope that you stay, because I will dive into some important topics. My intention, again, is here to give you key and current insights into common problems or pitfalls that I see in my practice when working with early stage companies or companies looking to scale, particularly in the tech world. Having said that, these problems are certainly not unique to tech. They come up in a lot of different industries. So the goal of today's presentation is obviously to provide a bit of concentrated knowledge and actionable strategies to, at the end of the day, help your company's bottom line. So on the slide here, I've got a bit of a roadmap of where I'm going to take you. The first topic I'll take you through is worker classification, which is very, very important. So we'll talk about the distinction, obviously, between employees and independent contractors, employees and volunteers, and employees and interns. The next, we'll talk about good hiring practices, and really what I want to hammer home is the point that employment agreements are so very important. So we'll dive into that after we talk about worker classification. From there, I will walk you through some of the key compliance issues that I often see in my practice. For the purpose of this presentation, my focus is going to be on provincially regulated work environments. So in the tech sector, most of you are presumably governed by the ESA, or the employment relationships are governed by the ESA as opposed to the Canada Labour Code. And lastly, we'll have a quick discussion about termination of employment and just some tips to keep in mind moving forward. Okay, so turning to worker classification. So if you're already working with a lawyer, or you're looking to retain one because you're looking to hire workers to support your business, one of the first topics that will come up is, apart from whether your business is federally or provincially regulated, is worker classification. So many early stage companies are understandably looking to stay lean, and so their preference is to avoid as much as possible the liabilities associated with hiring employees. I totally get it, right? There's a lot of benefits to hiring independent contractors. There's obvious cost savings, right? We've got, you're not required to pay vacation pay or benefits, CPP, EI. That type of arrangement also offers flexibility, and that contractors, can be hired for specific projects, for short-term needs. And generally speaking, entering into that type of relationship will reduce legal obligations in that you're, not required to pay Employment Standards Act entitlements because they don't apply, frankly, to contractors, assuming they're properly characterized. The other, benefit is that true independent contractors can't claim damages for wrongful dismissal. But again, the key is, are they true independent contractors? So at law, workers are classified based on the degree of control over their work and the degree of economic reliance on the employer for income. Engaging a worker as an independent contractor always carries risk. You're going to hear that come up a lot in today's conversation about, the distinction between employees and independent contractors. So there's always a risk that the worker is going to be treated like an employee. The fact that the parties have defined the contract between them to be that of an independent contractor and not an employment contract is unfortunately irrelevant for the most part. So while it's true that adjudicators, so whether it's the CRA or the courts, will consider the intention of the parties. So they'll look at the contract and see, is it a contract of service in that it's an employment contract, or an employment contract, or a contract for service. So an independent contractor relationship. They'll look to see does the worker charge and remit sales taxes or not. But apart from the labels, they're always going to look beyond the label here, and they're going to look at the whole working relationship to determine how is it that the parties are truly conducting themselves. So apart from looking at the labels applied to the contract, the key considerations in this area, they're listed on the slide here, but degree of control is a big one, right? So who controls when, how, and where the services are performed? One issue that often comes up is, can the worker subcontract the work, or must they complete it themselves? Obviously, if the worker can subcontract the work to another employee or someone else outside of that relationship, then there may be a finding that that person is more likely to be an independent contractor versus an employee. Ownership of tools is also relevant. So for the most part, a worker who owns and supplies the tools they need to perform the services is more likely to be operating their own business. If the employer supplies the tools, so, the laptops and, the uniform and all of those fun tools, or I guess the uniform wouldn't be a tool, but you get my point. The worker is more likely to be found to be part of the employer's business. Chance of profit, risk of loss is also a relevant factor. So, the question is the independent contractor operating their own business? Will they profit by completing work quickly and efficiently? Can they suffer a loss where the cost of their time in performing the work exceeds the income? So that's something, that's obviously an important factor here. Employees on the other side on the flip side here, they're paid an agreed amount of time spent working, and they're not entitled to increased profits through the manner in which the work is completed. Exclusivity is also a very important factor. A worker who operates their own business is free to choose the customers they work for. This freedom indicates an independent contractor status. Ultimately, employees don't have the freedom to choose who and when and where they work. They're required to follow the direction of the employer. Apart from these, I guess, four factors, there are other factors that are relevant that will come into the analysis as well. One being the length of the agreement. So short fixed-term agreements would tend to suggest an independent contractor status, whereas indefinite term agreements that are open-ended would support the opposite. The authority of the worker is a key consideration. So can the worker bind the corporation? Presumably, if you're hiring a contractor, they're not going to be in a position to bind the corporation. But there's certain times when that might be a fact that is relevant to the work relationship, and that type of finding would lead to a conclusion that the person is more properly an employee. Whether the worker provides their own insurance is also a relevant consideration. If they're required to provide their own insurance, then that factor might suggest more that this is an independent contractor relationship. So the bottom line is, if you wish for an adjudicator to treat your relationship with a worker as an independent contractor relationship, you do really need to give the worker as much independence as is reasonably possible, and you should treat the worker as though they're truly a separate business entity from your business. But I get that's not always as simple, because the business is your baby, right? And you want things done a certain way, at a certain time in accordance with your instructions. So in a lot of cases, it's just not feasible. What I can tell you is, after meeting with a client, more often than not, I will recommend that they enter into an employment agreement as opposed to an independent contractor relationship, even if the worker is the party pushing for the independent contractor agreement for their own benefit, because there's lots of reasons why the worker will want to be classified as an independent contractor. Obviously, they benefit from the relationship as well. But there are and I'll recommend that even if all of the factors that we've gone over suggest that there is an independent contractor relationship. At the end of the day, as long as there's an enforceable employment contract in place, the business can limit its liability in the event that it decides to terminate the employment, or the agreement. But with an independent contractor arrangement, if the worker is misclassified, which is a huge risk, the company could face significant legal and financial risks, including penalties, back taxes, potential wrongful dismissal complaints, among other issues. So even if the worker is considered a contractor, it is important to keep in mind as well that there is a certain threshold that they might cross over into becoming what's called a dependent contractor. And usually that happens when there's been a prolonged period of economic dependence on the company as their primary source of work. So if the company essentially becomes if that's their exclusive, they're exclusively working for that company, even if, again, all the factors of an independent contractor relationship exist, the fact that they're more exclusively working for the company and depend on the company for their income will suggest a dependent contractor finding. And this finding carries obligations to provide the worker with common law reasonable notice on termination, and typically allows the worker to join a union if you've got a unionized work environment. There's a well-known saying, if it walks like a duck and talks like a duck, it's probably a duck. That's very, very relevant when it comes to independent contractor and employee distinctions. So if after looking at the individual who's going to enter the independent contractor agreement, you come to the conclusion that they will appear to be an employment agreement, or sorry, they'll appear to be in an employment relationship with your company, then they're likely going to be an employee, and unfortunately, no amount of contractual drafting will likely remedy the situation. So, as always, you're going to hear this a lot today, but it's important to seek advice before you enter into these types of arrangements to avoid the potential liabilities that might flow from them. So the next topic I want to go over with you is volunteers. It's equally important to differentiate between true volunteers and an employee who is not remunerated, which is illegal. The Employment Standards Act is actually silent when it comes to volunteers, but the guide to the Employment Standards Act clearly sets out that volunteers are not employees and are therefore not covered by the ESA. Now, if you don't already have a copy of the guide to the Employment Standards Act, or you don't refer to it, in your HR practices, I strongly recommend that you review the guide. It's so very helpful. I use it daily in my practice. So that's just a quick plug to, I guess, the government for providing us with that resource. But back to the volunteer issue. So, essentially, employment laws do not apply to volunteers under the ESA. However, the fact that someone's called a volunteer does not determine whether that person is an employee and entitled to protections, much like the independent contractor issue. So there are times when, it will be unclear whether a worker is a volunteer or being labeled as such. And it's important to identify the factors that distinguish the two, because there's many instances where your business may be misclassifying the employee as a volunteer, resulting in that worker being denied wages and benefits, which they're ultimately entitled to. So according to the guide, and as I said, the Employment Standards Act is not helpful on this point, but the guide, what it says is that the main factors to determine whether someone is a volunteer or an employee are the following. So one, how much the business benefits from the individual's services. And two, how much the individual views the arrangement as being in pursuit of a living. Now, the fact that no wages were paid does not necessarily mean that someone's a volunteer. And the opposite is true. So the fact that there is some form of payment or an honorarium does not necessarily mean someone is an employee. Now, a significant factor that helps distinguish between the employee and a volunteer is the degree an employer benefits from their services. So I guess ask yourself this question: is the work that is essential to the business's operations being done by volunteers? If the answer to this question is yes, the individual is likely an employee. So this one factor was actually referred to in a recent Ontario court decision. It was actually a class action brought on behalf of a group of approximately 1,000 volunteers against a student travel agency they worked for. The court ultimately determined that the volunteers were employees and that the student travel agency had misclassified the workers as volunteers. In that case, the employer had the volunteers performing tasks that employees typically did. So a few examples from that case were, they assisted with all activities, they collected damage deposits from customers, they did passenger signups. So in addition to that, the volunteers also went through extensive training and worked long hours in exchange for a small honorarium, which fell well below minimum wage. The case ultimately settled, as most class actions do. The agreement in that case was that the company was on the hook to pay the class members $450,000, which I'm sure they would have avoided had they sought legal advice in advance of referring to these individuals as volunteers. I raise this case because, or just the volunteer issue, because it is not uncommon for early stage businesses to use volunteers in the early stages. But what I thought it might be helpful to do is to bring this issue to life with an example that might feel familiar or at least plausible in your world, the tech world. So imagine a startup called Productivity Boost. They're building a new productivity app, and like early stage ventures, they're trying to keep costs low. Instead of hiring paid testers, they recruit a group of volunteers to test features and track bugs. These individuals are expected to work regular hours, attend weekly meetings, and submit reports, all under the direction and control of the product team. Now, in exchange for their services, they get early access to the app, some gift cards, and a foot in the door at a promising new tech company. Now, here's the issue. Despite being labeled as volunteers, they meet nearly every hallmark of an employment relationship: control, integration, and expectation of ongoing work. And under the ESA, this arrangement likely amounts to an employee misclassification, meaning that productivity boosts at the end of the day would be on the hook for back wages, statutory entitlements, including vacation pay, wrongful dismissal damages, and administrative penalties, and more. So word of caution, be very careful if you're going to call someone a volunteer, and make sure you seek advice before you do so. The same is true for volunteers, for interns, but the ESA actually deals with interns, and practically speaking, interns who are performing work are generally entitled to minimum wage. There are certain exemptions, and specifically in relation to individuals who are enrolled in certain college programs. The ESA more helpfully defines, who is and who is not an intern. So the risk of the misclassification issue is not as evident as in the volunteer employee situation. So in terms of, I guess, to leave you with a best practice, any non-traditional work arrangement that walks and talks like employment needs you need to take a closer look at it. And I always recommend that you seek advice before entering into these arrangements. Retain a lawyer to draft the contract, and it's important to periodically review the relationship to determine whether it may have crossed the line into the employee-employer relationship. So that brings me to our discussion on good hiring practices. And as I said, specifically, this topic is about employment contracts and the importance of good ones. I'm sure most of you are aware, and if you're not, you're going to find out, but courts are very protective of employee rights. And while, some court decisions, or the pendulum might swing back and forth over time between, a decision in favor of the employee versus a decision in favor of the employer. We are, at the end of the day, in a pro-employee era, with obvious open season on termination clauses. This means that a large portion of the employment contracts that come across my desk on a daily basis for review typically contain provisions that are either clearly no longer enforceable because they either breach or have always breached an employment standard, or they're unclear, which at law has the same effect. So whether the termination clause breaches the Employment Standards Act or the employee's entitlements on termination are unclear, the implication for the business is that it will be on the hook for reasonable notice at common law. I cannot overstate how important it is to have enforceable termination provisions in your employment contracts. I also cannot overstate the importance of having written employment contracts with terms that are tailored specifically to the business and the employment relationship. I understand that hiring a lawyer to put together a contract can sometimes be costly. I also understand that you might not have time to hire a lawyer to draft the contract or review a contract before you enter into it with a new employee. I understand that. It's also so easy today to go online and find a template or ask ChatGPT to draft one for you. I have clients that I see who will reuse agreements that maybe their mentor shared with them, who uses that agreement in their business, or one that the business owner, when they were previously employed with another employer, they just basically reuse that agreement, change the names around and the dates, and that's it. AI is a wonderful tool, and both it and the web can be really awesome if you need a background education on what type of terms to include in an employment contract. But agreements that you find or create online certainly have their limitations, and most often than not, they're tailored specifically to a business that's not yours and a relationship that's not unique to your business. So it's really at the end of the day not actually relevant to your business, and that's important because you need your contracts to be relevant to your business. I don't mean to sound sales pitchy, certainly, but AI doesn't know what it doesn't know. I think we can all acknowledge that. And employment agreements are not a one size fits all. So it is very important that, if you don't have contracts already, that you get written contracts put together, have them drafted by a lawyer, specifically an Ontario employment lawyer, whether it's me or someone else. You need it to be reviewed because the laws are different in every province, and the laws are constantly evolving. In the tech world, IP agreements, confidentiality, non-disclosure agreements, restrictive covenants are critical for protecting your assets. And for this reason, it's critical to have these provisions in your contracts and to ensure that they're tailored specifically to your business and where necessary, limited in scope. Because again, courts are very, there's decisions coming out all the time which keep showing, courts, they sympathize with employees. As I said, it's really open season on employers, and a lot of these decisions are favoring the employees. So it's important that, again, your contracts are enforceable, and that you do what you can at this stage to protect your assets, because employees leave, and you might have to go after them in the future. And if you don't have an enforceable termination provision, your efforts will be significantly hindered. The problems associated with employment contracts tend to arise when a business decides to terminate an employee and provides them with a severance package in line with what their contract says. We also see it arise, during the course of like an M&A deal. You've got the purchaser doing due diligence, and they flag that there's a whole bunch of contracts that are not enforceable. So typically, you pay out the severance package and you think everything is well and all is fine. And then you find out that, well, the contract that, you provided to the employee that had a termination provision is not enforceable. Even if that contract was drafted by a lawyer 4 years ago, the law has changed over time because of all these cases that are coming out. And provisions sometimes are no longer enforceable. And that's very unfortunate for your business, but that's just the reality of the legal landscape in Ontario. As I noted earlier, if a court determines that the language in a termination provision is either unclear or if it breaches the employment standards, then the business might be on the hook for several months of notice under common law. And as I said, even if you've hired a lawyer to draft what 2 years ago would have been an enforceable termination provision, there is a risk that that termination provision may no longer be enforceable owing to developments in the law. So, it's equally, so on the one hand, it's very important to have contracts in place. On the other hand, it's very important that you get them reviewed regularly. But why don't I give you an example? So in preparation for my presentation yesterday, I decided to ask ChatGPT to draft me a termination provision that complies with Ontario employment standards legislation. So here it is. I hopefully can you see it? If not, I'm going to quickly review it anyways. But the result I received is a termination provision that is currently not enforceable due to a recent court decision in 2024. So my point earlier, limitations of AI. So in this case here, the termination provision in the court decision, I'll get to shortly, but let me just tell you here what the contract, or sorry, what ChatGPT spit out for me. So I'm just going to focus on the without cause termination provision. This one here obviously has given us more than that. It's given us a just cause termination provision as well. But again, my focus is just on the without cause termination provision. So ChatGPT drafted the following for me. The employer may terminate your employment at any time without cause by providing you with written notice of termination, termination pay, and/or severance pay, if applicable, or any combination thereof in accordance with the minimum entitlements prescribed by the Employment Standards Act, as amended from time to time. You shall not be entitled to any greater notice period, pay in lieu of notice, severance pay, benefits continuation, damages, or any other payment or entitlements under common law or otherwise beyond those required by the ESA. So that is a very clearly written termination provision that should withhold scrutiny. However, as I mentioned, this type of provision, which in my view would have been enforceable 2 years ago, is no longer enforceable. So ChatGPT has given me the opposite of what I asked for, a non-enforceable employment or termination provision. And as I said, there's a recent case that has just come out. It's called Defoe. So thanks to Defoe, that termination provision, which permits the employer to terminate the employee at any time would no longer be enforceable. So what happened in Defoe was that the employer had a termination provision that said the township may, at its sole discretion and without cause, terminate this employment and the employee's employment thereunder at any time upon giving the employee written notice as follows. I didn't include the rest of it because what really matters is the sole discretion language and the at any time language. So the court ultimately determined here that the clause breached the ESA by allowing the employer to dismiss the employee at any time, because according to the lawyer and the judge in that case, the court decision, that language, the ESA prohibits dismissal at certain times. And according to the court, that the inclusion of that at any time language, it basically flies into the face of the employment standards. So you're not allowed to terminate someone at any time, is what the court said. So the plaintiff's argument in this case was, a stretch in my view. A good portion, certainly all of my colleagues and a large portion of the labor and employment bars, particularly on management side, disagree with it. The court unfortunately accepted the argument, and at present it remains good law. There's always a chance that the Court of Appeal will deal with this issue. There's a recent appeal related to this coming up, but ultimately it hasn't been heard. So at present, having at any time language in your employment contract, there's a huge risk that it's going to be found to be not enforceable. So this means that if you have that language in your contract, it's time to review it and update your contract. So please, as I said, again, hire an employment lawyer from Ontario to review your contracts. But back to my earlier point, I mean, this is a real life example, or maybe not real life because it's AI, but it showcases the limitations of AI. And, it's a reminder of why it's important to hire a lawyer to draft your contracts from the outset. Now, before I move on to the next topic, which is compliance issues, I wanted to touch briefly on the subject of fixed term agreements. So fixed term employment contracts, layoffs, and the execution of employment contracts at the outset of the employment relationship. So on the topic of layoffs, the law on layoffs is really complex in Ontario and across the country. It's not unique to Ontario. While the ESA does permit employers the right to temporarily lay off employees for a prescribed period of time, Ontario courts have consistently held that an employer has no right to unilaterally lay off an employee unless the contract provides otherwise. So put another way, your business can only impose a layoff if it is specifically agreed upon in the employment contract. In other words, if there's a term in the contract permitting the layoff. So where there is no such term, it's likely that the layoff will trigger a constructive dismissal, meaning essentially that the business will be deemed to have terminated the employee and will then be on the hook for wrongful dismissal damages. So very, very, I caution you, if you do plan to lay off employees, please seek advice before you do so. And if your contracts don't have that provision in there, that's one thing that you should consider updating in the contracts. But again, seek advice before you lay off employees. I can't tell you how important that is. Next, in the tech industry, I tend to see a lot of fixed term employment contracts. There's nothing wrong with their use. In fact, it often makes sense in many cases to use a fixed term contract because, sometimes the employees you're hiring are typically only required for a short time. But it's just important to note that under Ontario law, if an employer ends a fixed term contract early, or there's no enforceable termination clause in the agreement, the employer could be on the hook for the value of the remaining term. So if it's a 1-year contract and you terminate them at 6 months, there's a risk that you might actually owe them an additional 6 months on termination. So for this reason, again, I strongly encourage you to seek advice if you have contracts reviewed if you do plan to enter into fixed term employment agreements. Just a word on the signing an employment agreement. It's really important to ensure that employees sign the documents before they start working. Again, I know that's not always possible because there's some urgency in getting employees working, and it might just be an afterthought getting once the contract's already been presented to the employee. But if challenged, there's always a risk that there's going to be a claim that the contract is not enforceable because the employee didn't sign it. And if the challenge, if that type of challenge is successful, the outcome will be that the employee is entitled to common law notice, which is a huge liability you certainly would not have expected, assuming you had, good termination provisions at the outset. There is some recent case law that suggests that a contract executed shortly after the employee commenced work will likely be enforceable. That assumes, of course, that the terms haven't changed from the date that it was presented to the date it was signed, but it's certainly not advisable to wait until after the employment has started. Make sure they do it first. Okay, so before the employee starts, just have them sign the contract, even if it's the morning of. Just make sure that they sign the contract, and of course, you should always give the employee like a week or two to review the contract if that's possible. Again, I appreciate that that's not always the reality. Okay, so moving on from employment contracts, key compliance issues that I see in my practice. Again, as I mentioned at the outset, my intention is not to walk you through all the relevant employment standards. There are lots of relevant ones, but I just want to touch on briefly just the ones that really stick out to me, given my experience working with startups and early stage companies. A few reminders off the hop here. Record keeping obligations are tremendously important. You're required to keep records. For the most part, I think it's 3 years after the employee has finished working, you have to have records. So that's hours of work, wages, vacation time, pay, name, address, birth date, access, hours of work, averaging agreements. Very important to keep records. I can't overstate that point. You also obviously must ensure that employment standards are being followed. And to ensure that you're doing that, you must understand what the standards are. So again, the guide is a very helpful tool. Also, speak to a lawyer if you need the type of 101 that this program is not today. The next thing is, you've got to provide like an employment standards poster to employees within 30 days of their hire date. You used to have to post it in the workplace, and now you're just required to give the employee a copy within 30 days after their hire date. Okay, so turning to, I guess, the juicy or the meaty topics that I wanted to go over with you today. So overtime, this is a common pain point from my side of things. In Ontario, overtime is generally payable after the employee has worked 44 hours in a work week. As I'm sure most of you know, it's 1.5 times any hour over 45 hours a week. There are obviously exceptions to this under the Employment Standards Act, so it's very, very important that you keep that in mind. In early stage ventures, overtime is not uncommon, and it may not occur to you that overtime needs to be carefully monitored or that proper record keeping is necessary, but it really is, trust me. A lot of my clients are surprised when I tell them that overtime is not based on whether an employee is paid a salary or not, and that in Ontario, salary employees are generally entitled to overtime, just like hourly employees, unless they fall under certain exemptions under the Employment Standards Act. We'll get into those shortly. But so, at the end of the day, it doesn't matter if you're salaried or hourly, you may be entitled to overtime hours if you work them. So make sure your business or your HR understands, the exemptions and who they may or may not apply to in your business. And if there's any questions, please reach out for advice before you proceed one way or the other. So the classes of employees who are exempt from overtime are as follows. And again, this is not an exclusive list. There's other exemptions under the ESA. So again, please visit the Employment Standards Act and the guide to help guide you through your decision making. So the first category is managers and supervisors. So obviously people who are in roles of authority and who can fire and hire and make significant decisions. Now, managers and supervisors are only exempt, however, if they perform non-supervisory and non-managerial tasks on a regular basis. So you've got to, that's a very important distinction. So if 50% of their day is managerial, but the other half is not, then it's possible that they won't fall under the overtime exemption. So you've got to truly look at the role to determine whether there's an exemption that applies here. Apart from that, licensed professionals, so lawyers, sad for me, I'm not entitled to overtime, doctors, engineers, accountants. There's certain IT professionals, including those involved in software design, developing, or software developing or managing information systems. This particular exemption might be relevant to your business, so please keep that in mind. There's also an exemption for certain sales people. So typically it's those individuals whose primary duties involve selling or negotiating sales for their employer and earn a significant portion of their income through commissions. So as I said, very important to not just look at the employee's title, but to actually look at what they're doing to determine whether this exemption applies. Overtime can be very costly, but it's sometimes unavoidable. There's certain strategies that you can put in place to try and lessen the blow, so to speak. A less expensive alternative to paying, overtime pay would be to offer the employee, time off in lieu of overtime work. So, but I appreciate that in early stage businesses, it's not great if your employees disappear for a few days because you need them working, you need those bodies in the office. It might be at the end of the day less expensive for you to hire another person if, at the end of the day, you've got a lot of employees working overtime. So keep that in mind as well. In your industry, it may make sense to consider the use of an averaging agreement. And what that is essentially an agreement between employees and the employee, employers and the employee, where the parties agree to average hours over a prescribed time period, not exceeding 44 hours. So if for example, it has to be limited to between 1 and 4 weeks. So if we use 2 weeks, for example, this means that if the employee works, let's say 44 hours in 1 week and less than 44 in another week, the total hours will be averaged over that agreement. So, you're not paying 44 hours, you're not paying overtime over and above 44 hours each week. It's going to be averaged over the 2-week period. With these averaging agreements, there's a whole bunch of criteria that you have to meet for that agreement to be enforceable. So again, another reason to maybe retain a lawyer to help put that together. At the end of the day, you can find that information online, but it's always good just to double check that you're ticking all your boxes. Now, it's not uncommon for employees to file an employment standards claim related to unpaid overtime or to add that type of claim to a wrongful dismissal complaint. We frankly see them all the time. So when the courts or the Ministry of Labor are assessing these claims, what they do is they consider all the evidence that's before them to make the determination on whether the employee has in fact worked overtime, and if they have, what their entitlements are. If your business does not keep records of employee hours, or if the records are challenged by the employee, the adjudicator will determine the issue based on the best available evidence. More often than not, the adjudicator will accept the employee's evidence because the employer either doesn't have the records or the records they have are just so poor that they're of little use. So it's very important to keep records. And I know that's difficult because, you're not always around to watch who's in the office and what they're doing and when they're doing and what time they're leaving. But if you have systems in place to help track that, it's always helpful if these claims eventually come to fruition. As I've mentioned already, liability can extend even if overtime hours are, and actually, sorry, I haven't mentioned this point, but even if you have a policy in place which says to the employee, you have to get permission to work overtime, liability can still attach because that's actually not good enough according to the court. Essentially, if you know, or the business knows or ought to know that the employee is working overtime and you fail to take reasonable steps to prevent the overtime, the business is likely on the hook for overtime premium. So very, very, high standard for the employer to meet. But that's just unfortunately the way the law is at present with respect to overtime. As I said, you should think about some way that, systems available to you to track overtime hours, whether it's, the employee has to punch in and out before they leave, or there's, some you're monitoring, systems to figure out who's working, who's not working. I appreciate that. That's a huge task for you to undertake, but it is important that we keep records for this reason, right? So that's what I have to say about overtime. Moving to vacation pay. So one thing I commonly see in my practice is, the assumption that you just have to pay vacation pay on, salary, or your hourly rate. But vacation pay is calculated on all wages, which the ESA defines to include commissions and bonuses and other forms of compensation. It is pretty common for employers to fail to pay vacation pay on commissions or bonuses owed to employees. What's also common is, the employer will show those payments as inclusive of the payment. So the employer isn't actually putting or adding vacation pay on top of that payment. They're showing it as inclusive. So if your business pays commissions or other forms of compensation, it's critical to ensure that you're paying the vacation pay on top. So just to give you an example, if the person earns, let's say, $2,000 in commissions, you actually need to pay vacation pay on top of that $2,000, not inclusive of that amount. There is an exemption for truly discretionary bonuses, but truly discretionary bonuses can't be tied in any way to performance or hours of work, and most bonus payments or commissions are typically tied to that, right? So, but there is an exemption. So, make sure you get advice on that before you decide not to pay it because you think you qualify for the exemption. Just like overtime pay, there are certain jobs that may be exempt from vacation with pay. That would include, the tech. So there's the salesperson exemption, accountants, lawyers. Obviously, it applies to managers, but I'm talking about, in the tech world, there's certainly. Tech professionals would not qualify for vacation pay. So just keep that in mind. But again, it's only certain tech professionals. So make sure that you follow what the guide is telling you, or again, seek advice on the issue. Oh, I see Christina has raised a hand. Sorry.
That's okay. I just raised a hand because you've got 3 minutes left.
Oh, okay.
And I know that you have a whole bunch more really incredible content. And I thought what we might do is my colleagues have dropped a poll for our guests that are on today. And I thought I might ask a couple of questions that are related to further interest. And then people who have really specific questions can connect in with Sarah and she can make an introduction to you if that's okay, Genevieve.
Certainly.
Awesome. Okay. Well, what I want to offer is this was such a really interesting conversation. And there are so many other topics that we were thinking about as it relates to the types of questions that were coming in today. There was a lot of questions that came in today, each one very different, and I loved it. So what we would love for our audience to do is indicate on the poll whether or not something like a webinar that has that anonymity and ease of online is more preferred over perhaps maybe like a small 10 or 12 person group where you can come in, have confidentiality, share a little bit of scenarios, and maybe match with other companies at your stage. So that's one. And the other is if folks on this call are interested in an added series or more topics. And so some of the topics or some of the questions that we regularly hear from both early stage and later stage companies are things that are related to legal considerations for hybrid and remote teams, risks of Ontario-based companies with staff outside the province or outside the country, when to actually hire in-house counsel, at what stage of growth is that often recommended? One of the things that some of our earlier stage, especially if they're not bootstrapping and they're raising capital, is having a total compensation package that's highly competitive that includes stock option or equity. And so for those who are still on the call with us, I would love for you to just drop in the chat the types of topics that are important to you that we maybe covered today, but you want to run more deep on, or that you hadn't considered before, or that's unclear to you. Again, our team will pull those out and look to design further education. Obviously, Genevieve, you covered a ton, and the focus on some early stage was awesome, and some of the focus on the later stage and unicorns in the making was really awesome. I know it's not supposed to be a 101, but you covered so much, and I want to offer my sincere thanks to you for preparing for today, for diving deep into some of the details, even doing sort of the showcase of what does AI look like versus, you know, what could a template look like versus having contracts developed for the role and for the company. So some of those mistakes we see happen within early stage because they are resource depleted and really just trying to build a company. And of course, as we see in larger companies where there's usually a process that happens, but certainly never hurts to do a check-in. So on that, I want to offer my final thanks to you. I invite folks to join us at an upcoming experience. Summer Shaker is coming up May 29th. It's going to be absolutely fabulous. 200 people or more in our space. And yeah, feel free to reach out to Sarah if you've got any more questions about what's coming up. And my thanks again to Robertson Hall Insurance for their ongoing support. And Genevieve, again, to you and Miller Thomson. We always appreciate having this connection to you. So for everybody else, take good care and we'll see you next time.
Thanks for having me, everyone.